Well, a recent case in the Supreme Court highlights the issue of home equity theft in some states, and it also raises concerns as to whether the same principle could apply to farmers and ranchers. Well, Roger McEowen with the Washburn School of Law joins us now with further perspective. And Roger, as always, thanks for your time this morning. Sounds like an intriguing topic. First of all, let's start with some background on equity in a home or, of course, a farm. What are some of the basic principles?
Yeah, well, good to be with you this morning, Janet. Equity is the difference between the value of the home or the farm and the remaining mortgage balance. So it's actually the primary source of wealth for many owners. And indeed, the largest asset value for a farm or a ranch typically is the equity that's wrapped up in the land. In the non-farm sector, primarily residences, they account for about 26% of the average household's assets. So it's a big deal. And certainly the government has the constitutional power to tax property and seize property to pay delinquent taxes on that property. But the question that's currently pending before the U.S. Supreme Court is whether it's constitutional for the government, such as a state, to retain the proceeds of the sale of forfeited property after the tax debt has been paid. Can they retain that surplus equity? That's the question that the court is considering right now.
So can you give us an update on the Minnesota case you've referred to?
Yeah, this is a case coming out of the Minneapolis area, and it's Hennepin County that is the local county. And they followed the statutory forfeiture procedure. The homeowner didn't redeem her condominium within the allotted time frame. And so the state ultimately sold the property and bagged the proceeds, including her equity in her property. So she sued, claiming that the county violated the Constitution's takings clause, federal and state, by failing to pay her equity that she had built up in that home. She also claimed that the action by the county amounted to an unconstitutional excessive fine, violated her due process, and was unjustly enriching the state. And she lost in the trial court level. She lost in the Eighth Circuit, and the U.S. Supreme Court said they'd hear the case.
So how does this compare to regulations that we see in other states, Roger?
Well, Minnesota is one of about a dozen states that have similar forfeiture procedures that allow the state to retain surplus equity. And we've seen this happen in Massachusetts. There was an alpaca farm that got caught up in this. There was also a Nebraska case about 5 years ago, out near North Platte. It was a $1.1 million farm that the state picked up on a $50,000 tax delinquency. And the Nebraska Unicam amended the law in Nebraska. And that's what's going to happen if the Supreme Court goes forward with this and does what many of us expect it'll do and reverse the Eighth Circuit. It'll force those 12 states to revise their statutory forfeiture procedures.
So what impact could the Supreme Court ruling, of course, have moving forward, especially on our farm grounds?
Well, beyond maybe perhaps forcing those states to amend their existing laws, those dozen states, I think it will further firm the base in the Supreme Court with respect to numerous Supreme Court rulings that have upheld private property rights in recent years. And this would be a step furthering in that direction. So personally, I think, or at least I hope it goes that way.
All right, Roger, as always, thank you very much for your insight today. Roger McEowen, he's with the Washburn School of Law. Of course, we appreciate him taking the time to join us. Also, go online to washburnlaw.edu/WALTR to read more on this case and others that Roger refers to.